Thank you so much. It's really a pleasure to be here. And before I say anything substantive, is it okay without the mic? Can you hear me well? Also in the online sphere. Okay, wonderful. Thank you. So indeed, I prepared some slides, and actually, as prepared structure for this presentation, I just say a few words about the importance of judicial independence for the European project. Something about ECHR and Court of Justice jurisprudence on judicial independence with a special focus on preliminary references, and then about the mutual trust preliminary reference cases. So my first point is the importance of judicial independence for the European project. And before I get into this, I brought you a picture which is depicting actually Professor Bernhard Schling, who in his farewell speech, in his Abschiedsrede when he retired, made a very, very important point. He used a metaphor. He said if he suffers a shipwreck and ends up on an island, all of his friends would be useful. The cook would know how to prepare food, the architects would know how to build a house, but he as a lawyer would be entirely useless. And this is because a lawyer is nothing, including a judge is nothing, without the structures. And I just want to make this point before I say anything else, because I will come back to it when we come to actual preliminary references. Okay, but the importance of judicial independence for the European project. So my first point concerns the interpretation of judicial independence. Of course, I could talk about the external aspect, which presumes that the body making a reference is protected against external intervention or pressure liable to jeopardize the independent judgment of the members of the court. The internal aspect is linked to impartiality and ensures a level playing field for the parties for the proceedings and their respective interests with regard to the subject matter of the proceedings. So the judge shouldn't have any interest in the outcome of the proceedings, apart from the strict application of the rule of law. But I would like to insert a very specific perspective here, and this is the perspective of fundamental rights. That's already a promotion for our book with Jesper Kromendijk, your speaker tomorrow. We are editing a book actually on judicial independence, and I just quoted Petra Bárd from this edited volume that will come out in 2025. Where he says that judicial independence is primarily something that appears in fundamental human rights texts of universal validity. So it's in the Universal Declaration on Human Rights, it's in the United Nations International Covenant on Civil and Political Rights. And this is not the right of the respective judge, but judicial independence is the fundamental right of every one of us, meaning persons, natural and legal persons, of course, with the exception of government. So independence is neither the privilege nor the right of the individual judges. Instead, the beneficiaries of the right to independent judges are persons and non-governmental organizations. So this is how the rule of law and democracy and especially fundamental rights are intertwined. It doesn't really matter how you achieve this independence, and here I rely on Martin Krigier's scholarship on tempering power. So Professor Krigier uses the metaphor of going to a hardware store. If you go to a hardware store, you don't want to buy a Black & Decker. No one wants to buy a Black & Decker. You want to hang a picture on the wall. It doesn't matter how you do it. But the outcome should be achieved, namely that power is tempered, is tamed, so that power is not arbitrary. And this is where the independence of the judiciary is, of course, of relevance for us. Now, the rule of law, and including judicial independence, is supposed to be in the DNA of European law in general. It's already established case law, even if it was not in the original fundamental text of European organizations, but it's in the case law with us since 1975 in the framework of the Council of Europe, since 1986 in the framework of the European communities. And indeed, there is a special role for judicial independence in the European Union, especially because it's the national courts, together with the Court of Justice of the European Union, that interpret and apply European Union law. So if there is no judicial independence at the national level, then European Union law cannot be properly applied. Now, against this background, it's interesting to see or sad to see eventually, rule of law backsliding and judicial capture in various member states. And as Professor Halmai and Professor Zsoneven emphasized right in the morning in their introduction, it doesn't only concern backsliding states, but there is a general decline in judicial independence and in general in rule of law in the whole European Union. Now, accordingly, because of this decline, the president of the court, the Luxembourg court, observes that making sure that national courts are providing effective remedies used to be sufficient to declare first principles, the primacy, unity, and effectiveness of EU law. Whereas in the past decade, the emphasis shifted to protecting the independence of the domestic courts, providing those remedies. Meaning that this problem of judicial independence is much, much deeper than it used to be a couple of decades ago. Now, this is a European matter, as I said, because the national courts together with the Court of Justice are applying, making sure that EU law is applied. So it's interesting to see that even though this is very much a European matter, if there is no judicial independence at the national level, then there is no mutual trust-based laws that are working fine. There is no laws in criminal justice that are working fine, neither in asylum cases. Nevertheless, we see a decline or an unwillingness rather on the side of the political institutions to actually enforce the rule of law and judicial independence. We know that the respective procedures, and on the slide you will see that Article 7 is under use, infringement proceedings are in decline. The Commission more and more refers to these preliminary stages, preliminary infringement proceedings instead of actually triggering the actual proceedings. And the conditionality regulations are also being abused rather for political games than being used in a very ethical and standardized manner. So since we do not see the relevant players which are supposed to uphold judicial independence at the European scene doing their job, we see other actors stepping in. And when I say other actors, it's sometimes the member states. Some member states are suing each other over the decline of judicial independence. And here I have, for example, the Dutch parliament in mind, which was toying with the idea of suing Poland for a lack of judicial independence, or the Finnish government toying with the idea of joining the Dutch in suing Poland, or it's actually the domestic courts that are suing each other, or that are asking questions, sorry, not suing each other, but asking questions in the form of preliminary references about each other's independence, or in some cases, even about their own independence. Okay, now the ECHR jurisprudence on judicial independence is framed in the form of a tribunal established by law in the sense of Article 6.1, which has certain key elements. There needs to be an objectively and genuinely identified breach of domestic law. The breaches should be fundamental to the procedure in question in front of the actual court, and the availability of suitable judicial review based on convention standards. Now, on the basis of these three key elements, in certain cases that are also depicted at the bottom of the slide, certain member states or certain high contracting parties courts or certain panels of these courts have been declared not to be courts. A court is only court in the European sense if it's independent. If it doesn't satisfy the requirements, then it's not independent. Now, in moving to the European Union, the black letter law is Article 2 TEU, Article 19 TEU, and Article 47 of the Charter of Fundamental Rights. Article 2 is stipulating that the rule of law is a shared value of the member states. And it has a background in Article 6 of the previous TEU. Article 19 obliges member states to provide for effective legal protection in areas covered by EU law. It's coming from actually established case law. And Article 47 of the Charter obliges member states to respect the fundamental right to a fair trial and effective remedy when implementing European Union law, again referring to Article 6.1 of the European Convention on Human Rights and Article 6.3 of the Treaty on the European Union. Now here I listed a number of key cases and concepts in judicial independence, but I know that the Honourable Judge will actually delve into the substance of what judicial independence actually means. So I don't want to spend too much time on that, and I also know that there will be a Romanian judge dealing with the Romanian cases. But let me say that the sea change to the debate of judicial independence and the invocation of Article 19 TEU came with the Portuguese judge's case, where a judicial trade union claimed that lowering the salaries of the Portuguese Court of Auditors members would violate the principle of judicial independence. Ultimately, the court failed to agree with this finding, but it also used the opportunity to develop the concept of effective judicial protection based on Article 19 of the Treaty on the European Union, read in light of Article 4.3 of the Treaty on the European Union, which enshrines the principle of sincere cooperation as the basis of member states' obligation to maintain the judicial independence of their national judiciaries. Now, in a number of other cases, the question arose whether the new disciplinary chamber within the Supreme Court of Poland constituted a court, and here I refer to AK and others, of course. And in this case, the court didn't answer the question directly, but it gave to the referring court a number of guidelines as to how to determine whether the court in question was independent or not. So it pointed to the possible irregularities in the appointment of the members of the chamber, the way in which such a panel exercises its constitutional responsibilities of ensuring the independence of the courts, whether the panel is independent from the legislature and the executive, whether the circumstances under which the new judges in Poland were being appointed were fair, the new powers with regard to the employment, social security and retirement of the judges, coupled with the lowering of the retirement age of the judges, the requirement to be served solely by newly appointed judges, and the autonomy in general of the respective panel. Now, based on these guidelines given by the Luxembourg court, the referring court actually came to the question, to the answer that the challenged Polish panel is not a court within the meaning of Article 47 of the Charter of Fundamental Rights and Article 6 of the Convention and Article 45 of the Polish Constitution. I am skipping the Romanian cases entirely because there will be apparently a discussion of these. And I will just jump to the non-regression standard, mentioning that the court with regard to a Maltese judicial reform managed to formulate the non-regression standard, saying that the judicial reform cannot lower the standards of the judiciary that the member state adhere to when it joined the European Union, which is a very controversial thing. And of course, there's a vast literature on that, whether it actually discriminates between member states that acceded earlier or that acceded later. All in all, we can see that as opposed to the previously discussed European Court of Human Rights' approach, the Court of Justice's perception is a so-called social perception. It uses a social perception test whereby the impartiality and independence of judges and courts must be assessed from the point of view of the citizens, who must have the impression, namely the subjective feeling, that there are factors such as appointment procedures, disciplinary responsibility, termination of judicial secondment, that affect the independence of judges especially vis-à-vis the executive and the legislative branches. Under this social perception standard, not only formal requirements matter, but also the way that these requirements are actually used in practice. Okay, now I will jump to some mutual recognition-based cases you might have seen and might have expressed internally the criticism that I haven't touched upon many preliminary references targeting judicial independence. And this is the reason for it is that I wanted to discuss separately the mutual recognition and mutual trust-based cases. The whole area of criminal justice and also asylum law, for that matter, is based on the principle of mutual recognition, which again is based on the presumption of mutual trust that every member state is a state based on the rule of law. And accordingly, every court has to acknowledge every other court's judgment in the European Union as its own. The lead cases are coming from the European arrest warrant framework decision, and accordingly, and here I'm just pointing to the LM decision from 2018, according to the court in Luxembourg, every suspect must be surrendered to another member state, even if doubts arise as to the independence of the judiciary in the requesting state. And the European arrest warrant or any other mutual trust-based law can only be suspended in general if the member state underwent an Article 7.2 procedure and has been sanctioned according to Article 7.3, something that never happened in the history of European integration. On a case-by-case basis, we can suspend surrenders, but only if it can be proven that there is a systemic problem in the member state, and it can also be proven as a second step that the systemic problem will affect the suspect directly if he or she is surrendered. This is something that puts Herculean hurdles on the individuals. We have just finished a European Union funded project, the STREAM project, and we couldn't find any cases. I mean, my colleague Jasper Kromendijk found one case where the test was properly used. Otherwise, such surrenders have never been suspended just because there was a doubt of judicial independence on the side of the requested state. If the test was properly used, it has been suspended, but not on the basis of the test that was established with regard to judicial independence by the Luxembourg court. Now, this, I might come to that, but this is problematic because in other cases, and Agnes already referred to that, the Court of Justice is following a different line of understanding of judicial independence. For example, in the prosecutor's independence cases, the Luxembourg court held that prosecutors do not qualify as judicial authorities for the sake of sending surrender requests to other countries if they can be instructed by the executive. Like, for example, it happens in Germany. Even if it never, ever happens in practice, even if the Landesminister in Germany has to give reasons why he or she would interfere into a case. But most importantly, it never really happens. But still, the potentiality that the executive can interfere with these cases means that German prosecutors, for example, do not qualify as judicial authorities. They are not independent enough. And you don't have to check on a case-by-case basis whether this or that public attorney or in this or that case he or she would be independent or not. No, there is a blanket ban for them to issue surrenders, European arrest warrants. Now, if you look at the twin judgments on the conditionality regulation, again, according to the Court of Justice, one can suspend funds to member states solely on the basis that judicial independence is jeopardized. Again, you do not have to check on a case-by-case basis whether this or that court would fairly decide, for example, a public procurement case. No, if there is even the semblance, or if there is a doubt of jeopardizing judicial independence, then you would theoretically suspend all funds to the given state. So this is the core of my criticism that Agnes was referring to. In a way, the Court of Justice is protecting EU money more than it protects suspects whose fundamental rights and procedural guarantees might be at jeopardy if they are being surrendered. Okay, so what does the Court of Justice say? Why does it insist on these two-step tests in the LM case in judicial independence European arrest warrant cases? Well, first of all, the court says not all courts are captured. So let's check whether the requesting court is captured or not. Now, I would say this really is a faulty interpretation of judicial independence, because even if the court is captured, it will never admit it, because this is what the courts are supposed to do. They are supposed to enter into a dialogue about the requesting state's independence. So basically, in a surrender case, the Dutch court, for example, has to ask the Hungarian court or the Hungarian judge, are you independent? Now, the judge is never going to say, yeah, no, I'm not, I'm sorry. Just don't give me the case. Even if the person is independent, you never know who would decide the case on appeal. And we all know that the nature of judicial capture is that it's first the apex courts, the Supreme Court and the high courts, which are being captured, not the lower courts. Okay, there is another argument on the side of the Court of Justice, namely that it would lead to impunity if surrenders would be suspended. Now, this is a very interesting idea of the presumption of innocence on the side of the court, I would say, presuming that everyone is guilty who is to be surrendered. In another case, XY, the court says victims' rights would be jeopardized if surrenders would be suspended. Again, this is a very interesting balancing between victims' rights and procedural guarantees. And most importantly, the Court of Justice says that depriving all judges, saying that the whole judiciary is dependent on the executive would deprive all judges, including the independent judges, from asking questions from the Court of Justice in the form of preliminary references, because only independent courts are courts, so only independent courts can ask questions. So if you declare a whole judiciary to be non-independent, then even the good judges, so to say, won't be able to ask or send preliminary references to the Court of Justice. Now, this argument is somewhat weakened by the fact that in a 2023 case in Getin Noble Bank, the Court of Justice actually admitted a question from a panel, from a court, from a judge who has previously been declared to be a non-judge by the European Court of Human Rights. And the court has many consequences. So first of all, it creates tensions between the European Court of Human Rights and the Court of Justice of the European Union by not taking into account what Strasbourg has to say about the independence of a judge. But the gravest concern is that the Court of Justice is basically legitimizing a Polish non-judge by making the case admissible and going into the merits of the case. By the way, the question in this case was from the neo judge, from the new, in quotation mark, judge, whether Polish judges who have been appointed before the regime change are independent enough to be called judges. The Luxembourg court said that's not a concern for European Union law. Even if a judge was appointed as a judge before 1989, it doesn't mean that he or she is automatically not independent. The person can still be independent. But the relevance of the case really is that a non-judge was able to send a preliminary reference to the Court of Justice of the European Union, thereby legitimizing a non-judge. Now, also reverse cases, and this is my final slide. Not only non-judges' questions are declared to be admissible, but real judges' questions are also declared to be inadmissible in a number of cases. So in Miasto Lovic, for example, judges had some concerns about the disciplinary proceedings that they had to undergo in case they turned to the Court of Justice of the European Union under the Polish legislation. And as if the Polish captured state wanted to prove their point, they were subjected to disciplinary proceedings just because they asked these questions. But the Court of Justice said this is all of no relevance to the actual case that needs to be decided. Therefore, the case was declared inadmissible. In a very similar case, I asked a Hungarian judge, Csaba Vasvári, asked whether he himself was independent enough to decide a case with a cross-border element. He had one question about the quality of translation and interpretation, and he had two important questions, generally asking about the health status of judicial independence in Hungary. And the court held that these two latter questions have not been relevant for the actual case in front of Judge Vasvári, and therefore they are inadmissible. However, because he dared to ask these questions, disciplinary proceedings started against him. And also, his questions have been declared to be illegal. It doesn't have any further consequences under Hungarian law, but still, this is also a sign for other judges not to ask these questions. Now, interestingly, therefore, the Court of Justice of the European Union had the same position than the Hungarian Supreme Court, the independence of which is questionable, saying that indeed these two judicial independence related questions were of no concern to European Union law and of no concern to the actual case, and it was wrong to actually ask these questions. Okay, so with these pessimistic thoughts of dubious cooperation between the Court of Justice of the European Union and captured courts, I close my presentation, and I'm, of course, very open to questions.